So I'll get going now. Good morning, everyone. My name's Joe Weiler, and it's my pleasure to say some opening remarks here. I'm a professor emeritus at the Peter A. Allard School of Law at the University of British Columbia, where I taught for 46 years before I retired a couple of years ago. And just a couple of words now about the anti-corruption law program. 7 years ago, my friend and colleague John Ritchie and I conceived and started to put together the program. So we're the two co-founding directors. And we were joined 3 years ago by our friend and colleague Norm Baldwin, and this past year by Dr. Alex Komarov as the directors of the program. Alex is their director now of research and programming. So back in 2016, we recognized that there were three organizations operating independently who were involved in organizing conferences and doing contract research about best practices in anti-corruption. And they had different core competencies. Where I'm from, the Peter A. Allard School of Law was doing, as you might expect, sort of teaching courses to enrolled students, graduate research, academic scholarship. The International Center for Criminal Law Reform as a UN-affiliated commission research center, which, by the way, in 2021 gave birth to the Vancouver Anti-Corruption Institute, which is now our co-partner in this program, and Transparency International Canada, which is the leading NGO in this field in Canada and globally through the Secretariat in Berlin. So whose function was to raise awareness and advocate for policy changes to fight corruption. So each of these three organizations was doing good work, and what John and I did was we put together a working partnership among the three organizations to cooperate and do joint work in organizing top quality continuing professional education. And since then, we've put on 40 seminars, conferences, webinars, colloquia in this field. So in a sense, this is a form of collective action where the organizations and the people, as you'll see, who contribute today, teach each other, about how to fight corruption. What are those best practices? So, and there was a major turning event for us in 2020 when the pandemic hit. And then with the support of the Center for Business Law at Allard, in particular, its then director, Carol Liao, we were provided with top quality technical support so that we can do these kinds of seminars. And we are very grateful to Carol's team and Justin Chor today for the backup that would be well beyond our core competency to actually get these kinds of programming to you. So many thanks to Carol, many thanks to Dean Nagai Pindal, who's given a huge support to this program, on an ongoing basis. So, and I'd recognize, because we're the University of British Columbia is the home in a sense of this program. We'd like to acknowledge with gratitude that the UBC campuses in Vancouver are on the traditional and unceded territories of the Musqueam Nation, the Squamish Nation, and the Tsleil-Waututh Nation. And UBC Okanagan in Kelowna is in the Sajik, Nation territory. So, and again, many thanks to our colleagues, Dr. Peter German, who is the head of the International Center for Criminal Law Reform and the director of the chair of the advisory board of the VACI, James Cohen, who has been the executive director of TI Canada, and welcome to Niam Leonard, who's now just come on as the executive director of TI Canada, for the ongoing, very active support for this program. It's a huge privilege and an honor to have Justice Austin Cullen join us today for his opening remarks, which will provide a framework for our other panelists for the discussion which we're going to have today. So thank you so much. Justice Cullen, for the work that you and your team did for 3 years as you came to grips with ways of combating money laundering and produced this monumental 1,800-page report with findings and recommendations, about what to do in Canada and particularly in British Columbia to fight money laundering. So it's my privilege now to introduce Jeff Simpser, who will be our moderator today. Jeff was a panelist in one of our sessions that we had, last fall on civil forfeiture and particular on unexplained wealth orders. I'm excited to say that Jeff is spearheading a new 8-week course on anti-money laundering called Dirty Money, the life cycle of money laundering, which is going to happen starting in early January until the end of February 2024. So he's the course leader of that, and he's going to tell you about that course in due course. So Jeff we're so grateful that you've taken on such a huge role within our group, and we look forward to the course and your contributions we thank you for what you've done and will do. So just a few words about Jeff. He's a barrister and solicitor in the Law Society of Ontario, a graduate of Osgoode Hall Law School, and then a Master's of Law from Queen's University Law School. For 30 years, he was legal director of the Ministry of the Attorney General, the Government of Ontario, until he retired last year. One of Canada's leading experts on asset forfeiture and anti-money law, and also a renowned scholar, actually, authored 2 books, Civil Asset Forfeiture in Canada and Canadian Anti-Money Laundering Law in the Gaming Sector. So a much sought after trainer and consultant around the world now. He doesn't stop. And Jeff, thanks so much for what you have done and what you will do to in this area of fighting corruption in Canada, and particular for the work that we will be able to enjoy with you through the anti-corruption law program. So over to you, Jeff.
Thank you, Joe. So good morning. Good morning to our friends on the West Coast. It's midday here in central Canada, and we have a number of friends from Europe. Hello to Maddie and Talon, and good day to you. So I'm Jeff Simpser, and as Joe said, I was Canada's first director of civil asset forfeiture when I worked for the Ministry of the Attorney General. I'm also an expert with VASHI, the Vancouver Anti-Corruption Institute that Joe mentioned, that's run by Dr. Peter German. And I'd just like to acknowledge, Dr. German's work really laid some of the foundations for the conversation that was had at the Cullen Commission that we're going to have today and continue to have. So I just want to recognize that important contribution that he's made. And Joe mentioned we're going to do 8 seminars, free webinars in January and February. They start the 11th. They're every Thursday in this time slot. And Dr. Peter German has agreed to be one of the feature speakers in the very first of those webinars, called What is Money Laundering? So today what we're going to do, we're going to have a conversation that really begins with reflections from Mr. Justice Cullen. I know he doesn't really need an introduction to almost everyone, I think, that's on this call. He's a storied lawyer. He was a prosecutor, highly respected jurist, and of course then headed the Cullen Commission. And following Mr. Justice Cullen's remarks, we're going to have a conversation with 4 people. Aaron Hunt, who's the Director General of the Financial Crimes and Security Division at the Federal Department of Justice, and a self-described policy wonk, which we very much appreciate. David Averon, who is the VP Legal at the BC Financial Services Authority. Phil Tautel, who is the BC Director of Civil Forfeiture. And last but certainly not least, James Cohen, who is pinch hit for us. He was for a long time the important voice for TI Canada. He's now with Moody's, but he has graciously agreed to help us out. So just in terms of format, the participants in the webinar, you can send questions to us, to the panel. We're going to try and leave a generous amount of time to take those questions up. Each of the 4 panelists will speak for roughly about 15 minutes. And with that, I'm going to turn the camera and the webinar over to Mr. Justice Cullen for his remarks and reflections.
Thank you, Jeff. My task this morning, as I understand it, is to highlight some of the essential issues, findings, and recommendations of the Commission of Inquiry into Money Laundering in British Columbia to provide the basis for a discussion which will follow about the progress and developments over the last 18 months since the Commission's final report was delivered to the Attorney General for BC and the Ministers of Finance and Public Safety and Solicitor General on June 3rd of 2022. As I noted in my letter, delivering the final report to the three ministers, the Commission heard from nearly 200 witnesses, filed 1,063 exhibits, and consumed over 130 days of evidence and arguments in fulfilling its terms of reference, which included making findings of fact respecting money laundering in British Columbia across 6 specific economic sectors in light of the actions or inactions of regulatory authorities, individuals with powers, duties, or functions in respect of those sectors, and law enforcement. The Commission was also obliged to make recommendations about the sectors, those 6 sectors, and any other relevant sector in view of its findings of fact. What motivated the provincial government to establish the Commission was the significant public concern fanned by extensive media reporting about the nature and extent of money laundering, mainly through casinos located in the lower mainland of British Columbia. Because in British Columbia, the provincial government shares revenue with gaming service providers, money laundered through gaming venues became an issue with a political dimension, as well as one which was concerned with organized crime, exploiting a method of laundering illicit funds in a way that used a government-regulated industry to avoid enforcement attempts. An unanticipated challenge which the Commission faced initially in March of 2020 was the onset of the COVID-19 pandemic and the necessary public health measures taken to slow its spread and lessen its impact on the community's physical and economic health. It became necessary to pivot from in-person investigations, interviews, and hearings to virtual ones using video conferencing technology. Commission staff and lawyers had to adapt and adjust to the new reality created by the pandemic and enabled by the technology. Due to the hard work and the adaptability of the Commission lawyers and staff, the Commission concluded without unreasonable delays or cost overruns. The final report I mentioned was issued on June 3rd, 2022, just over 3 years after the Commission was established on May 15th, 2019. With appendices, it was just over 1,800 pages long. There were 101 recommendations. I think it will earn me some gratitude if I tell you now that I am not going to attempt to wedge a synopsis of the final report into whatever remains of the 20 minutes I've been allocated for these opening remarks. What I hope to have achieved by the close of these remarks is to explain in relatively short compass why it was important to launch the Commission of Inquiry, and to talk about 3 recommendations which I made that I considered to be critically important in the ongoing battle against organized for-profit criminal activity. Money laundering is an engine of organized crime. It is how criminals who are seeking profit can realize, reinvest, or otherwise use the proceeds of their illegal activities. Those charged with the responsibility of preventing crime and dampening the motivation to commit it have limited resources and understanding of the varied nature and true extent of the role that money laundering plays in enhancing criminal enterprises within the larger community. In several ways, the Commission was able to cast light on money laundering activity in British Columbia, initially by exploring the issue of quantification, That is, how much money is likely laundered in British Columbia annually. Secondly, by exploring some of the methods used to launder money in British Columbia. And thirdly, by exploring the relative ineffectiveness of the regulatory and law enforcement agencies set up to abate or prevent money laundering in British Columbia and elsewhere in Canada when contrasted with other comparable jurisdictions. The Commission was also able to explore the underlying deficiencies in understanding and attitude which led to this situation in British Columbia, particularly within the gaming industry, and to propose an antidote to prevent its occurrence or reoccurrence. A significant issue confronting policymakers and decision makers in British Columbia and in Canada who need to address money laundering lies in assessing the dimension of the problem that it represents. Typically, that is a first step engaging the nature and the magnitude of the response. The Commission heard evidence from various sources in considering the size of the money laundering problem, including hearing from economists and criminologists about their methods and attempts to quantify the funds annually being laundered in British Columbia. The Commission also engaged academic researchers to conduct some original research about the quantum of money laundering, and I also heard evidence about a single money services business that was involved in laundering over $220 million annually through a sophisticated scheme that relied on underground banking and a lax regulatory environment in the gaming sector. I also heard evidence from Dr. John Zdanowicz with respect to suspicious trade transactions, revealing that in 2019, there were 10,000 such transactions reflecting up to $8 billion moved out of the province and $16.5 billion moved into the province in a context suggestive of money laundering. I also considered a 2020 report from Joris Verwerda et al., estimating that $37 billion are laundered annually in Canada. Although many of the significant agencies in the AML regime in British Columbia and more generally in Canada are federal and thus beyond the jurisdictional reach of a provincial commission of inquiry, such as the Money Laundering Inquiry for BC, I was able to assess and gain understanding of some weaknesses and gaps in those agencies insofar as they had an impact on British Columbia's AML regime. One of the most frequent complaints about the effectiveness of the federal AML regime centered on FINTRAC's role in receiving and analyzing information about money laundering threats and communicating that information to the relevant law enforcement bodies. It does not appear that the number of FINTRAC's disclosures to law enforcement agencies is comparable with the number of reports it receives, nor with the scale of money laundering in British Columbia. To illustrate that conclusion, FINTRAC received 31 million reports in 2019-2020. In that same year, however, it disclosed only 2,057 intelligence reports across Canada and only 355 to British Columbia authorities. A possible explanation for the high reporting rate to FINTRAC and low volume of intelligence reports to law enforcement and low level of charges and convictions for money laundering is that Canada's AML reporting regime favors a high volume but low value approach. On a per capita basis, reporting entities in Canada submit 12.5 times more reports than similar entities in the US and 96 more times than those in the UK. In the US, for example, FinCEN received 21,683,802 reports, while the United Kingdom received 573,085 reports annually. The estimated cost to the reporting entities in Canada annually is about $6.8 billion. The expressed concerns about the effectiveness of the federal AML regime include the lack of a strategic vision, its inability to get actionable intelligence into law enforcement's hands in a timely way, the absence of a legislative framework for the exchange of tactical information about money laundering activities, and the erosion of law enforcement resources to pursue money laundering offenses. I concluded that the federal regime fell short of its mandate to oppose money laundering by failing to dedicate sufficient or effective resources to do so. I was persuaded that the best way for British Columbia to tackle money laundering within its borders was to create a three-pronged approach to it. First, to create a provincially based intelligence and investigative unit. Second, to add value in the provincial context by developing a more effective asset forfeiture regime. And third, by creating a new office, the Anti-Money Laundering Commissioner, to coordinate the provincial effort to identify money laundering risks in the economy and to identify and encourage implementation of measures to address those risks. The recommendation for a provincial money laundering intelligence and investigative unit evolved from the need to establish a unit that was more responsive to the characteristics of money laundering in British Columbia, in British Columbia's particular context. In keeping with that imperative, I recommended that the unit be housed within the Combined Forces Special Enforcement Unit, or CLU. That placement would give the provincial government more oversight and visibility into anti-money laundering operations, as well as more control over the hiring and retention of qualified officers and civilian specialists adept at investigating often complicated and multi-layered offenses. The apparent need to develop a more potent asset forfeiture regime developed from the Commission's consideration of more successful asset forfeiture regimes in other jurisdictions and their importance in operating as a barrier to the growth and expansion of organized criminal groups. I could consider the use of unexplained wealth orders as a valuable tool in the struggle to curb criminal profiteering, and with the benefit of a thorough and thoughtful opinion on the constitutionality of such a measure by the Honorable Thomas Cromwell, I recommended that the province adopt it as part of its asset forfeiture regime. One of the Commission's tasks was to determine whether there was corruption involved in the agencies or individuals who were responsible for overseeing the gaming industry during the 10-year period where money was extensively being laundered through casinos in the Lower Mainland. Although I found no evidence that there was corruption, I did find a failure of will among some of those responsible or positioned to prevent the profligate money laundering in the sector. In addition, I did find some deficiencies in the approaches and attitudes of the industries in which money laundering appears to flourish, and in some agencies set up to guard against money laundering in various economic sectors. I concluded that money laundering, as with any entrenched and complex problem, requires a strong political will to oppose and deter it. I would add that the strong will needs to reside not only in government, but also among the responsible regulators, law enforcement agencies, and industry leaders. It was against that backdrop that the idea of an anti-money laundering commissioner was developed. The mandate of the commissioner would be, 1, to oversee and monitor the provincial response to money laundering using various ways, including by keeping those involved in AML activities informed of existing and emerging AML risk activities and responses. 2, by undertaking, directing, and supporting research on current money laundering issues. 3, by issuing policy advice and recommendations to government, law enforcement, and regulators on money laundering issues. 4, by auditing and reporting on the performance of provincial bodies with an anti-money laundering mandate. And 5, by coordinating groups and efforts to address money laundering issues. So long as the conversation about money laundering continues to flourish, as it will during the course of this session and in the February session that Jeffrey Simser is organizing, and ideas continue to be exchanged about how best to oppose it, there is reason for optimism. The persistent and obvious difficulty in maintaining a focus on combating money laundering is that neither its presence nor its harms are obvious. The debate among academics whether money laundering causes harm is representative of the lack of focus on the reality that underlies it. No one would argue that fraud, theft, human trafficking, trafficking in child pornography, drug trafficking, or other profit-driven crimes are both present and obvious in the harms they inflict on individuals and on society as a whole. Money laundering is simply the realization of profit from those harmful activities. A failure to recognize the significant role that money laundering plays in the criminal economy and culture is a failure to recognize the harm that it springs from, and an equal failure to recognize the importance of combating it. So I do commend those who are organizing this session and the session which will take place next February, because it is keeping a spotlight on what I consider to be a very important and ongoing topic for discussion and resolution. Thank you.
Thank you, Mr. Justice Cullen, for your remarks. That's the pandemic affected all of us, obviously, in profound ways. But on a small personal note, I had the privilege of testifying twice before the commission. And when I was first approached by council, I was really excited to see one of my favorite cities, Vancouver. And that was the effect of the pandemic. I didn't get to go to Vancouver. I will say, I think things are really changing. We've recently seen, for example, administrative monetary penalties issued by FinTrack, $1.3 million to CIBC and $7.4 million to RBC. So we're starting to see some change. And as someone who's come from sort of the law enforcement side, I was always concerned not just about the level of reporting of FinTrack, but the ability of law enforcement to take that on board and process it. Because if it just goes onto the desk of a police sergeant and doesn't get read, then where are we? Anyway, we've seen a lot of change, a dizzying series of measures. It's hard to keep up with some of the things the feds have been doing around the last couple of budgets and the most recent fall economic statement. Fortunately, we have Erin Hunt here, and I'm going to turn to her so she can help us kind of unpack where we are and where we're going. Erin?
Good morning. It's my pleasure to be here today to speak to you about the Cullen Commission and the Department of Finance and the federal government's effort to strengthen Canada's anti-money laundering and anti-terrorist financing regime. And I think as Jeff started out, as I was writing my remarks for this event today, it got longer and longer and longer about all the things that we have been able to accomplish in the relatively recent past and where we're going in the future. And so I hope I don't overstay my welcome in terms of all of the things that we've been able to move forward. I thought maybe I'd start with a quick overview of Canada's federal regime. So Canada's anti-money laundering, anti-terrorist financing regime involves 13 departments and agencies working with provincial and territorial colleagues to combat money laundering and terrorist financing in Canada. The Department of Finance is the lead for Canada's AML/ATF regime overall. Canada's regime operates on the basis of 3 interdependent pillars. So the first is policy and coordination. The second is prevention and detection, and the third is investigation and disruption. And I say this so that I can preface my remarks in the fact that the Department of Finance and my role is to support the policy and coordination of the regime, including the legislative and regulatory framework. I work closely with colleagues across the government and engage them on a daily basis to support the work of the regime. At the same time, I'm Canada's head of delegation to the Financial Action Task Force, which is the international anti-money laundering, anti-terrorist financing standard-setting body. Canada continues to be an active member of the FATF and its global network of regional bodies, and has taken on the role of FATF Vice President until 2025. Canada will undergo its next peer review of our AML ATF regime in 2025. So today's discussion on how Canada is strengthening our regime is also relevant in that context. The Government of Canada has welcomed the Cullen Commission's final report and the richness of the information it contains on the scope of money laundering, not only in British Columbia, but across the country. The report highlights the challenges faced by policymakers like myself, also regulators and law enforcement authorities and our private sector to be nimble and to adapt to constantly evolving methods used by criminals. It places a spotlight on the threats and harms of money laundering and why it's a problem Canadians should care about and talk about at the dinner table. By raising public awareness of money laundering and the challenges of effectively tackling these complex threats, the report can help us garner support for bolder domestic measures that we can advance as a country alongside our partners across all levels of government and in the private sector. Money laundering doesn't stop at borders, domestic or international. The problems faced in British Columbia that were brought to light in the Cullen Commission's report to effectively combat this complex threat mirror national challenges and in many cases, global challenges. Finance Canada is reaching out to our counterparts in British Columbia to ensure that we identify opportunities for cooperation, avoid overlap, and prevent silos in our response. The Cullen Commission's findings reinforce the need to continue to make improvements and reinforce the need for ongoing work and prioritization of AML ATF efforts. And I'm pleased to say that Canada's AML ATF regime is a priority for the Government of Canada. And the political and public service will that Justice Cullen referred to in his remarks is there. In every budget since 2019, the government has announced measures to combat money laundering and terrorist financing, including legislative amendments to strengthen our regime, and is committed to advancing further measures in the future. At the federal level, the government has committed to respond to the findings within its jurisdiction. And I can say we've responded. So here, let's go through it. I've divided into 5 buckets of comments and happy to talk to you through some of these responses. So first, as Justice Cullen noted, one of the findings was the lack of a strategic vision. In March 2023, the federal government published 3 regime documents that help lay out a strategic path forward. The Department of Finance published Canada's Anti-Money Laundering, Anti-Terrorist Financing Regime Strategy 2023 to 2026. This sets out the government's plan to combat money laundering and terrorist financing over the medium term, including actions to improve performance and outcomes. Priorities actions are grouped along 4 themes: increasing operational effectiveness, addressing legislative and regulatory gaps, improving regime governance and coordination, and contributing to international efforts to combat money laundering and terrorist financing. The government also published the Report on Performance Measurement Framework for Canada's AML regime. Lastly, the government published the updated assessment of inherent risks of money laundering and terrorist financing, which we affectionately called the NERA, which is the update from the first version in 2015. And the NERA is a really important regime document because it helps us understand the money laundering and terrorist financing risks, and it contributes to our ability to effectively combat these illicit activities. It informs our operational decisions about priority setting and resource allocation and helps us focus on those threats with the greatest economic, social, and political consequences. It also helps our reporting entities and other members of the private sector apply risk-based approaches and mitigate their risks. As we prepare for Canada's next mutual evaluation by the FATF in 2025, our vision and our understanding of these risks will be increasingly important as the international standard will place renewed emphasis on these elements of our regime. In June 2023, the government launched a public consultation taking a broad look at Canada's regime. The consultation document is not as long as the Cullen Commission Report, only a little over 100 pages, but it takes a comprehensive look at Canada's regime and seeks views on multiple proposals on how to improve it. The consultation discussed criminal justice reforms, improving operational effectiveness, including a Canada Financial Crimes Agency, enhancing information sharing, targeting new risk areas, providing an effective regulatory framework, and greater provincial, territorial, federal cooperation. We heard from nearly 130 respondents, covering a broad range of stakeholders, reporting entities, industry associations, provinces and territories, NGOs, academics. The feedback we received was substantive and reflected the importance our regime partners place on these issues. We continue to engage with industry representatives and other groups through bilateral engagements, events like this, and our public-private advisory group we call ACMLTIF, to continue to have conversations about the proposals. This feedback and these documents will help inform the parliamentary review of the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, which will begin in the near term. This will give us an opportunity, again, to explore in greater depth how Canada's anti-money laundering, anti-terrorist financing regime can remain responsive to the evolving threat environment and further advance strategic priorities. Second, the Cullen Commission found a lack of priority and resources for money laundering investigations. Improving this outcome with respect to investigations, prosecutions, and asset recovery remains a top priority for the regime. The need to improve these enforcement outcomes was reflected in the regime report on performance measurement, as well as in previous international and domestic assessments, including Canada's 2016 FATF mutual evaluation and the 2018 parliamentary review. Since 2019, the government has made investments of $319.9 million, that's exact numbers there, with $48.8 million ongoing to strengthen data resources, financial intelligence, information sharing, and investigative capacity to support money laundering investigations in Canada. This includes resources for integrated money laundering investigative teams and IMIT upgrades at the RCMP to handle higher volumes of complex information and evidence, and increased dedicated forensic accounting expertise available to support financial crime investigations across the country. More recently, the government announced its intention to create a new Canada Financial Crimes Agency, which is to become Canada's lead enforcement agency for financial crimes, bringing together the expertise necessary to increase money laundering charges, prosecutions, convictions, and asset forfeiture results in Canada. My colleagues at Public Safety Canada are leading the design of this new agency, including defining its areas of responsibility and how it will work with existing enforcement players at various levels of government. This isn't a quick fix. It's a long-term solution. It's important that we get this right, and it will take time. To complement these investments, the government has also introduced a series of measures so that law enforcement has the tools needed to support investigations and prosecution. This includes amendments to the criminal code to add the fault element of recklessness to the money laundering offense, and as outlined in the 2023 Fall Economic Statement, to add provisions to the offense of laundering the proceeds of crime to support the prosecution of third-party money launderers. This also includes modernizing the criminal code to keep pace with financial technology by allowing police to freeze and seize virtual assets with suspected links to crime, and updates to provisions related to the search, seizure, and restraints of proceeds of crime. The government has also created an offense if a money service business, including those dealing with virtual assets, operate while unregistered, as money launderers have been known to use unregistered MSBs to launder the proceeds of crime. And it has criminalized the structuring of transactions to avoid triggering FINTRAC reporting, another money laundering technique. Third, the Cullen Commission raised concerns with the information sharing and the ability to get actionable intelligence to law enforcement in a timely way. Budget 2022 provided significant new funding to strengthen FINTRAC, $89.9 million over 5 years and $8.8 million ongoing. This represents a 24% increase in FINTRAC's annual budget and a 13% increase in new staffing. These investments are supporting the modernization of both compliance and intelligence functions at FINTRAC to improve efficiency in managing increased reporting volumes and also the timeliness and impact of financial intelligence. As the director of FINTRAC, Sarah Paquette, recently stated, These will ensure FINTRAC is in real time. To complement these investments, the government has announced legislative changes to strengthen the information sharing tools under the regime. Budget 2023 announced amendments to the Criminal Code and to the PCML-TFA to enhance information sharing between CRA, so the Canadian Revenue Agency, and law enforcement, and between FINTRAC and law enforcement, and to enhance FINTRAC's strategic intelligence analysis related to threats to national security. It also included changes to allow FINTRAC to better support decision-making on national security risks and enhance information sharing powers between FINTRAC and the Minister of Finance. The 2023 Fall Economic Statement proposes to enable FINTRAC to disclose relevant information with Environment and Climate Change Canada and the Departments of Fisheries and Oceans to further combat environmental crime. These legislative amendments have been included in Bill C-59. Through Budget 2023, the government also introduced legislative amendments to the PCML-TFA to provide whistleblowing protections for employees who report information to FINTRAC. These amendments were passed in June. The Cullen Commission heard from witnesses that some employees feared retaliation for reporting suspected money laundering activity to appropriate authorities. These changes will help address that gap. Further, the 2023 Fall Economic Statement proposes amendments to the PCML-TFA and to the Customs Act to enhance Canada Border Services Agency's authorities to combat trade-based money laundering, another consideration raised by the Cullen Commission. The government also announced its intention to create a trade transparency unit to analyze trade data and work with domestic and international partners to detect, deter, and disrupt trade-based financial crimes. This builds on regulatory changes that were finalized this year to increase the penalties for cross-border currency reporting, which the Cullen Commission found not sufficiently dissuasive. With the consultation that we launched earlier this year, the government is considering further ways to enhance information sharing, including private-to-private information sharing, and to get actionable intelligence to law enforcement in a timely way. Fourth, the Cullen Commission highlighted the importance of tighter regulation of high-risk sectors. The rapidly evolving and complex nature of financial crime requires ongoing updates to our legislative and regulatory framework to address these emerging risks, and the federal government is working to do so. Recognizing the potential risks for money services businesses, in Budget 2023, we announced measures to strengthen the registration framework for money services businesses, and as I noted before, created an offense if they operate while under-registered. To help prevent financial crimes in the real estate sector, the federal government announced its intention in Budget 2022 to extend anti-money laundering, anti-terrorist financing requirements to all businesses conducting mortgage lending in Canada, and the regulations were finalized and will be brought into force next year. We propose further changes to address fraud and money laundering by extending the requirements to title insurers and by requiring real estate representatives to identify unrepresented parties and third parties in real estate transactions. These will be brought forward in a regulatory package that's under development. And we've brought new sectors under the AML regime. This includes armored cars, crowdfunding platforms, and payment service providers. And most recently, and this is a direct response to the Cullen Commission, we have announced in the Fall Economic Statement that we will address risks related to white label ATMs, which are highly vulnerable to money laundering. The government is proposing to regulate the ATM acquirers that connect the ATMs to the broader financial system. And finally, through our consultation, the federal government continues to explore other areas of emerging and high risks, including virtual assets and luxury goods. More to come on those fronts. Lastly, the Cullen Commission highlighted the importance of a pan-Canadian approach to beneficial ownership transparency. I wanted to end on this point because I have a fellow panelist, James Cohen, who has been very active on this issue. Beneficial ownership registries are increasingly the norm worldwide. And as the International Standard Setter, as the FATF, it has 2 recommendations specifically on beneficial ownership. Following an initial set of amendments in 2022, I am pleased to share today that the government passed on November 2nd this year the final legislative amendments to implement a free, publicly accessible, and searchable full beneficial ownership registry for federal corporations. This registry will cover federal corporations governed under the Canada Business Corporations Act and will be scalable to allow the beneficial ownership data held by provinces and territories that agree to participate in a pan-Canadian approach. It's expected to be launched in early 2024. Bill C-42 also amends the PCML's TFA to allow the government to make regulations for discrepancy reporting, which will supplement Corporation Canada's compliance and verification to promote an accurate and verified beneficial ownership registry. We are also engaging with provincial and territorial governments on our pan-Canadian approach, and I'll end by welcoming the recent launch of Quebec's registry and the legislation passed in British Columbia to help promote a pan-Canadian approach. And with that, perhaps I will pass the floor over to James. Thank you.
Thank you, Erin. That's really good. We're going to change the order up a little bit. We're going to go next to David. Obviously, a lot of the Cullen Commission's remarks were directed at the province. I know you can speak to a few of those. Before I turn it over, though, a few questions are coming in, and that's fantastic. Please keep them coming, and we're going to try and reserve time at the end to get to as many of them as we can. But David, over to you.
Thanks, Jeffrey, and good morning, everyone. And I regret having a look at the list of attendees. Boy, we have some very distinguished attendees here this morning, so that's a bit daunting. But I don't think I'm going to be able to deliver a full seasonal measure of tidings of comfort and joy. But I think there's going to be some comfort and joy. And as I was reflecting on things preparing to speak this morning, I think there's been substantial progress. I think as I was in the run up to this, I was probably underestimating just how much has been accomplished over the last while since Judge Cullen delivered his report. Just a little bit about BCFSA. I'm not here on behalf of the provincial government. We're in the provincial realm. We're the principal financial services regulator in the province of British Columbia. Just a little bit of history. It's BCFSA, BC Financial Services Authority, is an amalgamated, consolidated regulator. Really, just quick snapshot of the history. The FICOM, Financial Institutions Commission, was in government. It regulated pension plans, credit unions, trust companies, and insurance companies in the province, and associated with it also was the Registrar of Mortgage Brokers. That was sent out of government to become BCFSA in 2019, and in 2021, the Real Estate Council, which is where I was, which regulated the real estate service industry, realtors, and the Office of the Superintendent of Real Estate were merged with BCFSA, becoming part of BCFSA. So it's kind of a consolidated regulator. It's got 10 statutes to become 11 when the Money Services Business Act is fully implemented and enforced. It has royal assent, but it's not enforced yet. And we cover probably something like, depends how you slice these things up, 25% of the provincial economy. You can imagine with pension plans and real estate and so on. It's a very substantial amount of the provincial economy, a lot of money flowing around. We do institutional regulation of credit unions, and we do professional regulation, much as, say, the Law Society would, but in respect to realtors and mortgage brokers. It's a very interesting situation. There were approximately 30 recommendations that Mr. Justice Cullen made, which relate to BCFSA. From all of those areas, some yet to be regulated. We have virtual asset as well that is not regulated yet in our purview, but recommendation pertaining to credit unions, real estate, of course, mortgage brokers, and the money services businesses. Of those 30, some relate fairly directly to us and are more or less within our purview, more or less within our powers. A number of the regulations depended very much, were contingent really on provincial government action. Some we would be able to do more or less ourselves. Some, it's a bit of a dance. We would be kind of codependent and interacting with the provincial government, but there are 7. I'll speak specifically to those a little later on. Those are recommendations 11, 12, 15, 19, 22, 24, and 45. And I've got a bonus one that I'll get to later. In the interim time, in the last 18 months, we've largely been waiting for direction from the provincial government. That's what's recorded and stated in our service plan, which is a public document the province requires of us. Although there was lots happening, quietly, we've committed to doing what we can. We haven't wanted to get too much ahead of the provincial government. For example, if you're bringing about requirements for the real estate service industry, there are 30,000 realtors in British Columbia. If you were having to amend that later because of a variance of the provincial government direction, that's a big problem. So we've been waiting for specific direction, but doing a lot of things behind the scenes, some of which were underway even before the commission did its work. For example, the realtors and mortgage brokers now are receiving anti-money laundering education as part of their professional licensing. We did the realtors well before the commission. That was kind of a first that attracted a lot of attention. It was kind of a hit. The Law Society was interested, Notary Society was interested, and so on. So that was kind of a good lead there. We have an information sharing agreement with FINTRAC. We had implemented criminal record screening a long time ago of realtors. That's been implemented as well for mortgage brokers as part of their licensing. And in our disciplinary work, of course, for misconduct, there continues to be professional disciplinary prosecution of realtors and mortgage brokers for money laundering related activities. That's been ongoing. Money laundering is because we do not have a specific anti-money laundering mandate under any of our statutes. It technically is sort of on a par with any other breach of any other an infraction of any other kind of legislative provision or activity, but the reality is it's probably first amongst equals in importance, given its public importance and its prominence. A big development, of course, is the enactment of the Money Services Business Act and the Mortgage Services Act. The Mortgage Services Act will replace the Mortgage Brokers Act, which is a longstanding piece of legislation. The Mortgage Services Act is really going to be a counterpart or parallel to the Real Estate Services Act, which regulates realtors. It's a full-scale professional regulatory enactment. It fulfills a number of, at one swoop, it fulfills a number of Judge Cullen's recommendations. It establishes managing brokers within the mortgage broker context. Educational requirements become more formalized. They've been there, but they're more formalized and will be more extensive. Penalties are significantly increased, $250,000 for individuals, again, parallel to the Real Estate Services Act, and disgorgement of misappropriated funds or ill-got funds. So those kinds of things have been done, and those fulfill a lot of the recommendations. The Money Services Businesses Act is going to be similar to that which they have in Quebec, which is essentially a registration licensing scheme. It's not a full-blown professional disciplinary statute. It gatekeeps entry into the profession. It's not a profession, I suppose. Gatekeeps entry into the activity, and it allows for penalization of those who are practicing in an unregistered way. So it gatekeeps for suitability and so on. So those have, I think, accomplished quite a bit of what Mr. Justice Cullen recommended in his report. Let me talk to the specific things that are out there now and some of the things that are ongoing. Quickly, those 7 that I mentioned, recommendation 11, that was an easy one, at least in the first half. I recommend that BCFSA make inquiries with FINTRAC to determine whether it's going to be instituting a source of funds inquiry requirement for licensees. So I personally have satisfied that by inquiring with FINTRAC, and that will be part of a parliamentary review next year for the proceeds of crime. statute, and that is certainly a possible outcome. So I think from our position, that will probably be wait and see to see what comes out of that for FinTrack. But I would think that at the end of it, it's very likely that one body or the other will institute a source of funds requirement. That's recommendation 11. Recommendation 12, BCFSA use its rulemaking authority to mandate brokerages demonstrate the existence of an anti-money laundering compliance program. We're working on that. I think it's there's a considerable likelihood that that will actually happen. When we use our rulemaking authority, it's not merely a matter of kind of sitting down and writing the rule. There's a legislative drafting, legislative council is involved. There's mandatory public consultation, and then it has to receive provincial government approval. Fairly elaborated process, but I think it's, and I'm just crystal ball gazing here, I think that's going to be likely to come about. 15, I recommend that the Registrar of Mortgage Brokers make it a requirement that applicants provide an extended criminal record and police background check. That's essentially done. 19, the Registrar of Mortgage Brokers requires education. That's done. 22, I recommend BCFSA impose a positive obligation on real estate licensees to report suspected unregistered mortgage brokering. That's being worked on now. Very likely that will come about. Yet to be seen, but we're working on it. 24, recommend that BCFSA work with the new dedicated provincial money laundering intelligence and investigation unit. I understand the province, that is contingent on the province. I understand the province is looking into establishing that unit. And then there would be a view to an information sharing partnership. That would be an easy one, but of course that depends on provincial action. Recommendation 45, I recommend BCFSA develop anti-money laundering guidance for credit unions. Up till now, we've been relying on OSFI's B8. OSFI doesn't use B8, their guideline B8, and we are working on, for the next fiscal year, some more specific and local guidance specifically developed for credit unions. So that's very likely to come about too. Now, the little bonus one pertains really to recommendation 47. Province provides sufficient resources to BCFSA to create and staff an anti-money laundering group. We haven't got the additional resources, but we have created the group, but that's a recent development. We've taken that platform, and it will not merely be a liaison group. It will not merely be anti-money laundering, although that will be its principal activity. It's going to deal with financial crime in general. So that's been underway the last few months. As a conglomerate regulator right now, we're kind of in an inventorying stage. What have we got? Make sure all the left hands know what all the right hands are doing. Where it will be responsible, I'm chairing it, it's going to be responsible for coordinating our internal activities, being the liaison for external inquiries and activities, making sure everything is harmonized and making sure things are being implemented properly and promptly. Last thing I'll say is that over the last few weeks, we have been working with the AML Secretariat of the provincial government. That's a small coordinating clearinghouse group within the provincial government reporting into the Ministry of Finance. And they are going to be giving us what feedback they can on where the province would like us to advance things beyond what we're doing now, or take a slightly different approach. I think they're working towards producing an interim report on the provincial response broadly to Judge Cullen's recommendations, the Cullen Report. And that may well be something they're aiming to do in the spring and summer. I have to say, I don't expect we're going to get any very prominent formal direction from the provincial government on things, but that's just my expectation. I don't think we're going to get a formal AML mandate. Helpful in some ways as that might be in overcoming some of the restrictions on confidentiality and sharing of personal information, even within an organization where you got 11 statutes that kind of silo some of these things. But I think there's been quite a bit done already, actually. And I'm feeling pretty good about it, and I think we're going to see even more coming up as I've described. It's going to take a little while, but I think within if we have another one of these in 18 more months, a good part of that list of 7 that is yet unfulfilled, be worked upon. I'll have some comfort and joy to supply there. So thank you. Thanks, Jeff. Back to you.
Yeah, thanks, David. So Mr. Justice Cullen, in his remarks, pointed out the importance of asset forfeiture as a tool to disrupt money laundering. And we're lucky to have Phil with us. There were 3 of the Commission's 101 recommendations were directed towards civil forfeiture, and particularly one around unexplained wealth orders, which I think BC have now quickly become Canada's leader in that space. So with those opening remarks, I return it over to my friend Phil for some thoughts and comments.
Thanks very much, Jeff. As you've noted, there were 3 recommendations. The last one, 101, was the launch of an unexplained wealth order regime for British Columbia. The recommendations came at a key time in the evolution of the program. In the first decade or so of the program, we were very much a instrument-based litigation group. The police sent houses, the police sent cars. That's what we forfeited. The house was generally a clan lab, a marijuana grow. So the evidence was really limited to the instrumentality of the house, not necessarily the investigation of the proceeds component. It was sort of the tail of the investigation and the litigation. Over the last decade, and we're now coming up to the second decade of the program. Program's about 20 years old now. We've moved very much from an instrument-based litigation group to a proceeds-focused investigation and litigation group. And in order, as anyone on the call may be aware, taking on criminal investigations or civil investigations involving proceeds are highly complex and highly resource intensive. I don't want to say it's a slam dunk to do an instrument case. It's not, but the evidence is right in front of you. It either is a clan lab or it's not. But proceeds investigations involve document production from banks and complete asset tracing. It's an enormously intensive undertaking. And because of that, you need, for a sophisticated problem, you simply need sophisticated tools. It's pure and simple. Whether you're involved in medicine, engineering, or police work, if you have a sophisticated problem, you need a sophisticated tool. And the unexplained wealth order comes along at a time when it has been used and under different names jurisdictionally around the world. There are reports that Jeff himself, as well as the Cullen Report, has done on the results of unexplained wealth orders. I think they're promising overall, but I think these are still early days. And if you look at the timeline from the time Mr. Justice Cullen and the Cullen Commission recommended this was June 2022. We received direction from the provincial government in November of 2022, so about 6 months later, to launch this. We had effectively passed the legislation by March or April of 2023, and we issued our first unexplained wealth order in November. So a year from the time we were given the direction. As of last week, we've issued our second unexplained wealth order, more to come in queue. So there's no question that we have the caseload and the right type of cases. It is a sophisticated tool. It's not a tool that's used just randomly for every single case. You have to look at the specific case. And as the Cullen Report considered and recommended, you use it for the upper echelon, the top end of the hierarchy. So it isn't going to be the street players or the medium level managers that you're going to use it on. You're going to use it on the people who are really running the operations and who have the sophisticated techniques behind them to bury their wealth inside nominees. It's as simple as that. And so that's been one of the key pieces. There has been a lot of learning for us on this in drafting the legislation. Jeff alluded to the fact that in his report, and as well, that the UK was one of the first most well-known ones out of the gate. We were able to learn in hindsight from people's good results as well as their bad results. And one of the challenges we found out is one of the first places the UK starts with its investigations is with tax information. It's a good starting point for them to build the basis. And as you may recall, one of the original requirements was that the criteria for obtaining an unexplained wealth order was to do a gap analysis or a delta analysis between someone's income and the value of the asset being pursued. And the bigger the delta or the bigger the gap, the more likely you would achieve success in obtaining that unexplained wealth order. Now, it assumes one thing in this jurisdiction is that the civil forfeiture in BC as well as Canada would have access to that information. And for sure, the hurdle to that is substantial. I don't know if that's going to happen in my lifetime. We're challenged right now by receiving the most basic of information. As been alluded to already, we are going into an examination in 2025 by the Financial Action Task Force. And that means 2024 will be a key year for fixing the problems and the lack of integration between the federal operations and the provincial operations. And so far, we've had excellent conversations with our federal colleagues. But one of the key challenges for us, that is, we are solely doing or moving in almost a complete fashion to chasing proceeds, is our office, the BC CFO, as well as our colleagues in the other provinces, have no access to FinTrack reports. So there's a mountain of gold sitting out there waiting to be mined. Not only can we not request them, but we can't even receive them as proactive referrals. So they may well be sitting on the desks of law enforcement rather than on our desks that could be actionable and taken on. So that's one of the challenges we've raised. We've received very positive feedback from our colleagues, but of course, proof's in the pudding. These changes will have to be made if we're going to be effective. Unexplained wealth orders will require access to information beyond just what the respondent provides us with. So we're hopeful and we're optimistic that as these unexplained wealth orders roll out, we fully expect there will be challenges to them. There have been challenges in other jurisdictions. Jeff and the Cullen Commission both acknowledged and that these are facts of what's going to happen when they roll out for the first time in Canada. I think the opinion of Justice Cromwell was very informative and was probably one of the key pieces in giving that comfort to launching them, both on the constitutional side and the charter side. But ultimately, it will be the court that will decide this. If you look at the nature of Civil Forfeiture Act itself, it wasn't until 6 months ago with the Angels Acres decision in British Columbia that after almost 2 decades of civil forfeiture being in Canada, we finally resolved once and for all that the forfeiture of instruments is considered intra-virus, is considered constitutionally valid in British Columbia and elsewhere. So it gives you an idea of just how long this takes. And if you look at Justice Cromwell's opinion, it was delivered in between the original decision from the BC Supreme Court saying that the future prong, the forward prong of instruments was constitutionally invalid. And that may have sort of colored his opinion. And since that time, the opinion was delivered. Of course, we've now determined that it is constitutionally valid. So all in all, I see 2024 as being a key year for the provincial CFOs to launch these sophisticated tools, not just in British Columbia, but in other provinces that are watching what's taking place here. But I would say the key element for our success will be fixing the lack of integration between ourselves and our federal colleagues, and specifically the federal legislation, that it's not so much that it doesn't speak to the provincial legislation, it actually impedes the ability of us to do our work. So, Jeff, thanks for the opportunity.
Terrific. Thank you, Phil. One of the problems and one of the reasons you need an unexplained wealth order process is that good money launderers, especially professional third-party money launderers, use shell entities in order to create an opaque corporate structure that makes it very hard for police and for law enforcement to follow the money. And it's on that point, I think, I'm going to turn last but not least to James, who has been a really vocal advocate for the need for things like an ultimate beneficial ownership registry. And thank you, James, for coming in and pinch hitting for us and sharing your great experience. So I'll turn it over to you.
Great. Thank you very much, Jeffrey. And thanks for inviting me onto the webinar, and I'm filling in for my colleague my former colleague, I should say, Sasha Caldera at Publish What You Pay Canada. And we were part of the, Sasha still is, the End Snow Washing Coalition. I was part of it when I was at Transparency International Canada up until recently, and we worked on the beneficial ownership file for 7 years. Essentially, when I first came on to TI Canada, and we were even working on it before that, and I was reminded recently that there were great civil servants who were even trying to move the government on beneficial ownership transparency well before our coalition started. A lot of people got this recommendation moving and all the way onto Justice Cullen's agenda, and thankfully Justice Cullen took it up and put it up as a recommendation number 52, which we believe that the federal government, the BC government, others were all waiting for as a signal. So we're chomping at the bit to see that recommendation 52. And as Jeff said, it's to address the layering structure, the opaqueness, the tools that are often most used by criminals around the world. We don't see a registry as a panacea or a silver bullet to solve money laundering. No tool is within money laundering. Even once we get all of these great tools put together, money launderers and criminals and terrorists and kleptocrats and tax dodgers will be inventive and unfortunately find new ways, and we're going to have to deal with that. But to leave the status quo as it is doesn't work either. The genesis of this recommendation coming out is, I think that it makes sense that it wound up in the Cullen Commission, because the idea first really struck a nerve in British Columbia, especially the lower mainland. That's where we focused our first report when I was with Transparency International Canada, even before I joined, on the beneficial ownership regime in Canada in general. And what I think a lot of Vancouverites were noticing is that empty condos all over the city being purchased for millions of dollars, appearing or not appearing, I guess is the right way to describe them. And that something fishy was going on. Now, I used to work at Transparency International in UK, where the similar feeling was going on in London of who's buying all these homes. We then published another report looking at the Greater Toronto Area real estate, finding billions of dollars in risky assets and real estate there that nobody knew who the owners were. And so with beneficial ownership transparency, this, as Aaron pointed out, is a recommendation or a tool that's been expanding around the world. The UK was the first to use it, just as Phil noted with UWOs. There was a time when the UK was a real leader on anti-corruption, anti-money laundering. And just because you go first doesn't mean you get it right. There were a lot of problems with the UK registry. Things like no drop-down menu for geography or where you're based. People could type in any age range without it being verified, from 0, which is a very enterprising infant. I know there's a lot of pressure with this new UK government on entrepreneurialism, but that's just too much. All the way up to 99. People can still have a business, but there was no verification system within it. But luckily, it was a public registry. So the first people to critique the registry was not, in fact, the government. It was civil society. A great organization, Global Witness, put out a fantastic report about the UK registry. So our coalition here in Canada has been pushing that publicly accessible registry all these years for a number of reasons. One is to have those extra eyes to scrutinize the data, but also to deter the criminals. And the data point for this, yet again, Global Witness found this in their first review, is that Scottish limited partnerships were being used, were being exploited by criminal groups. And there was connections to this from investigative journalist units for years. And then whenever Scottish limited partnerships were incorporated within the UK's register, significant persons of significant control registry, there was an 80% drop in SLP incorporation. So that gives an indication that there was exploitation that was used. So this is another one of the reasons, as much as we'd like to say that law enforcement or any other government entity would be there to scrutinize what's going on in the registry, having it open to civil society, to the investigative journalists, is a deterrent, and B, helps sift through those mountains of data so that it can be brought to law enforcement's attention. So with that, we've been pushing for the federal level, but thankfully within BC, there was a lot of movement, first from now Premier David Eby back when he was in opposition, bringing this, and ultimately finding its way into Justice Cullen's commission. So we're exceptionally happy to see Bill C-42. Aaron, I'm now getting to your point. You can get the congratulations from us. For somebody who is critiquing the government for so many years about what to do, it's only proper that I applaud the government when they do something right. I note that when this event was published or put up on LinkedIn, I did see a comment saying, what has changed in 18 months? Well, knowing this government, not anything. And I never aim to be somebody to feed the cynicism. I always aim to be someone to help create change. And it's important people know that change happens. I think David has pointed out a lot of change that has happened since Justice Cullen's recommendations. Phil pointed out changes, and Aaron has pointed out changes. Are they the right changes? You can critique that legitimately. Are there enough changes? You can also critique that. But to say nothing happened, I think, is to give into cynicism and to buy into the idea that people can't identify a problem and push their government for change. And with that, I'd like to talk about Justice Cullen's report and the impact of the Cullen Commission more broadly. And I think Aaron's detailed list of what the federal government has been doing pre-Cullen Commission and post-Cullen Commission is really important. I'll critique a little. Well, I guess, Aaron, you were saying that the government has addressed this since 2018, but not without a lot of push from outside actors. And we were ringing the alarm bell. We were very happy to see the government make these pushes eventually, and now hearing it. And I think the culmination in the Canadian Financial Crime Agency is going to be a big change. Now, whether it was Justice Cullen's intention with the recommendation of an A&L commissioner to push the Fed's hand, because a big part of the critique within the report, as we heard from Justice Cullen, is the handling of the information. And even as Jeff said, what happens when FinTrack gathers that information, it goes to law enforcement, it just sits there. There's a lot of hope being put into the CFCA, not to put too much pressure on Public Safety Canada. And we've got 2 weeks left of 2023. Maybe we'll see a plan for what the CFCA is going to look like. Maybe not. I'd rather they get it right than put pressure on them, but I don't want the deadline to go on forever. But I do hope they take this opportunity that the CFCA has a mandate to be as broad as possible to do their job right. And in a coordinating fashion. As we heard, there are many actors involved, as Aaron said, within Canada's AML regime, that stepping on toes and creating jurisdictional problems isn't the right way to go, but a coordination function and even enhancement of tools function could be the right way to go. And this doesn't even get to the aspect of, we're talking about the PCML-TFA, the Proceeds of Crime, Money Laundering, Terrorist Financing Act, and some degree Criminal Code. Unfortunately, I think a lot of people are overlooking the CFPOA, the Corruption of Foreign Public Officials Act, which in 2018, AML was in the headlines and stayed in the headlines since then. If we all remember, CFPOA was up in the headlines in 2018 with the SNC Lavalin case and became a very political thing, and then kind of dropped off the radar because there haven't been many remediation cases or foreign bribery cases since then, if any. So we might see those going back into the headline. But that's just to say the all-encompassing nature of the CFCA. And looking forward, I think talking about where the moves are, this is, of course, the BC audience is very interested in this and what came out of the BC nature. There was Justice Cullen saying nobody was specifically corrupt, but there was a lot of pardon me, Justice Cullen, if I'm getting the exact word right, willful blindness, turning blind eyes, and we're not in a position to do that anymore. I think Canadians are quite understanding we're not in a position to do that anymore. And BC is acting on it. I'm sitting here in Ontario. Last year, the outgoing Auditor General published a report on Ontario's casinos that you can pretty much match to what we heard about the Cullen Commission. And lots of experts said it, that once the pressure is placed on BC, that money is going to move somewhere else. Ontario, being the biggest economy in the country, needs to step up, as do other provinces. And Ontario also needs to step up on the beneficial ownership registry. Bravo to BC for passing the legislation on the registry, is blatantly saying that they want to connect with the federal registry. Bravo to the province of Quebec for already having public accessible information on their registry. We hope to see that they'll sync up with the feds. I think there's a lot of the smaller provinces who will probably see the advantages of working cooperatively with the feds on this, if not to work on the feds supporting their data management systems to directly send BO information directly to the feds. But Ontario has to play its part as the biggest economy in Canada. And then that just leaves this acknowledgement of we are in a higher risk area than when a higher risk world than when the Cullen Commission started. With supply chain disruptions from COVID, from the war in Ukraine, from other high-risk geopolitical issues, from climate change and critical minerals in BC, in Ontario, and the desire to implement those into rare earth minerals and not have countries that are less than friendly and outright adversaries have access to those. We have to look at the same tools for anti-money laundering in the risked areas of our financial flows and our licensing and permits around mining, critical minerals, the grants and permits we have to dual use technologies and sensitive telecoms technologies. So I think that hopefully the couple of years lead in time that we had to the Cullen Commission of flagging money laundering challenges in Canada and the many amendments that Aaron has pointed out, we see that this needs to keep spreading into the overall heightened risk atmosphere that Canada finds itself in the financial flow system. So whether Justice Cullen realized it or not, and I think he did, the implications of this report are far rippling through the whole country, not just even on AML, but to our very national security and other realms. Thank you.
Thank you, James. And I know, a couple of your remarks really, the civil society, so the sponsors of this webinar are civil society. We have TI Canada, obviously, and the Anti-Corruption Law Program and the Vancouver Anti-Corruption Institute. And I know that those three groups have not lost sight on what we do with foreign corruption and those kinds of prosecutions. So we have a lot of questions, and I'm just going to kind of fire them off to the panelists. We'll get to as many as we can. Before we do, just to remind folks, everyone that has registered for this will get an email inviting you to register. We have another 8 units coming up every Thursday, starting on January 11th and into February. Aaron has been kind enough to do another one with us. And there, if you look at the agenda, there are just some amazing experts from around the world that are going to come in and help us out. So I'm going to go to the questions, and David, I think you're first. And the question was about the implementation of the Mortgage Services Act and the Money Services Businesses Act. The question was around the rollout, but also about when do we have any information on the process to comment on the draft regulations for those two pieces of legislation?
Yeah, there was public consultation on both of those acts in 2020, or proposed acts. I think I'm not directly involved. I think the regulation and drafting is pretty far advanced, and I don't know that there's going to be public comment. There may be, so a little bit of ignorance on that, but it wouldn't surprise me if there isn't, but I can't answer beyond that. I think both of those will be implemented. It's going to be either this coming year, the one we're on the cusp of, but it could slip to 2025. Depends on so many things involving the provincial government as well as ourselves. So,
Great.
and everything has to be ready to go, right? That's a major undertaking, new IT systems, all of that. So everything has to be ready day one.
Thank you. The next question, I'll start with James, and Aaron, you might have comments on. So behind the events of the commission were whistleblowers and protection of whistleblowers. And I don't know, James, if you have any comments on what we do in Canada or are about to do or should do in Canada vis-a-vis whistleblowers. And then Aaron, I know you've mentioned some federal initiatives around FinTrack. So James, if it's okay, I'll start with you.
Yeah, sure. A profile or a portfolio I always kept an eye on, but I know this question came from Sandy Boucher, who is far more of an expert, an advocate for change on whistleblowers. So, in applauding people who can push for make change, I'll applaud Sandy and a lot of his colleagues at the Center for Free Expression at Toronto Metropolitan University who have pushed this issue. Off the top of my head, basically, I'm just repeating what Aaron said, that the legislation, Bill C-42, has whistleblower protection for those reporting towards the Corporations Canada for discrepancies on CFCA. I know, and so not to paraphrase you or put words in your mouth, Sandy, I know there was disappointment around some of the recent analysis on whistleblower legislation in Canada and lack of amendments to whistleblower protection that a lot of experts had been advocating for. Sandy, I'll leave it to you to put it in the Q&As if other people can read those, the laundry list of changes that you wanted. I'll leave it to Aaron to make any more specific points.
And so, Aaron, before I turn it over to you, there's another question, maybe you can combine the two. So one of the questions is asking whether there's any movement on lawyers as potentially regulated entities and subject to the FinTrack, and where we are with conversations with the federations of law societies and so on. So if you wouldn't mind taking those two up, Aaron.
Sure. I'm glad we started with some easy questions as part of this conversation. So I think, as I mentioned in my remarks, one of the changes that we felt was important to bring forward in legislation was whistleblower protection under the PCMLTFA, so under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, and that's specific to disclosures to FinTrack. And so that builds on the protections that already exist in the criminal code, but this allows for employees to protections to disclose to FinTrack should their employer in some way try to prevent them from making that disclosure. So we think that's an important step and responds directly to some of the criticisms, I guess, or the comments that were made through the Cullen Commission. On lawyers, this is seen and was seen in Canada's 2016 FATF mutual evaluation as a significant gap in Canada's anti-money laundering and anti-terrorist financing regime. It was an issue that we also consulted on through our consultation paper that was released this year. Since 2019, the government has worked closely with the Federation of Law Societies of Canada to explore issues related to money laundering and terrorist financing in the legal profession and to strengthen information sharing between law societies and the government of Canada. And so we will be continuing to work with the Federation on this collaborative approach.
Terrific. And I've got a question. It was kind of addressed to you, Aaron, but I'm going to start with Phil just to let you catch your breath. Phil, what needs to happen in terms of the relationship between civil forfeiture authorities in Canada and both FinTrack, and can anything happen with the Canadian Revenue Agency, with Custom and Border, in terms of what I've written about as information gateways, but can you give us some ideas as to what you'd like to see happen to make the system less siloed and more integrated?
Yeah, I think that's really important, Jeff. I think that information sharing within British Columbia has been accomplished. We were able to, within the Act, get positive information sharing agreements with our colleagues at the BCFSA, with the BC Securities Commission. So that's all been built in. We now have a nice legal framework. We simply need to have really the same thing with our federal colleagues. FinTrack, we see as a strong repository of it. The BC Security Commission already can receive FinTrack reports. So it's simply as easy, perhaps, as changing the legislation to add the BC Securities Commission and a civil forfeiture body that exists within a province. We're certainly doing that work. The idea that a two-person law enforcement agency in Northern Alberta could request a FINTRAC report that never does proceeds of crime investigations, and civil forfeiture offices in Canada that almost exclusively are doing money laundering investigations, it seems a little bit absurd that you would say the easy answer is to get that. The tax information is a whole different, it's sort of that bridge too far. So we're trying to do this in steps. The FINTRAC one makes common sense. We think it's an easy deliverable. And I'm certainly not hearing anyone saying why the only issue that was raised recently was, well, what happens if civil forfeiture gets out in front of law enforcement? So in other words, FINTRAC delivers a report and the civil forfeiture office launches actions against properties. It may impair or impede an ongoing criminal investigation. So that would be a risk to the criminal side. And the easier answer to that is coordination. It's simply ensuring copies of that is delivered at the same time to law enforcement and to ensure we wouldn't impede an investigation. Parallel proceedings in the provinces are already taking place, where there are prosecutions taking place on the left and civil proceedings taking place on the right. And there's more than enough case law in Canada that says these proceedings can run in parallel. So I think there's easy wins for information sharing and hard wins. With respect to tax information, it's important to know that we already receive tax information anyway, but it's unfortunately through the discovery process. So it's a fight to get it through the discovery process to get it there. And obviously, for obvious reasons, it's extremely hard to get from the defendants. Most of them don't want you to have it for obvious reasons. They're making $20,000 but spending $2 million a year. So either they're relying on their income taxes, or they're getting their money from something else. So that's the challenge for us, is we do receive it, but once it's a roadblock is put up by the defendants, and that's where unexplained wealth orders come in. I mean, really trying to fight through the court for 3 years to get the defendant's documents, or going to an unexplained wealth order that creates a rebuttable presumption. This is a unique and sophisticated tool to get behind all those roadblocks that are thrown up to prevent us. So instead of litigating over 5 years, you can litigate over 5 months. Either they have a rational explanation and we go away, or they don't have a rational explanation and we can amend our pleadings and pursue that vigorously. So I think the short answer is there's easy wins on the information sharing and hard wins, but we're hoping that the FINTRAC starts as the easy win.
Right. Aaron, I don't want to put you out totally on the hot seat. I don't know if you have thoughts on that. And then thoughts more. I think I heard there were 130 different submissions made to the department from your summer consultation. I don't know if you can update us on where you are. That had to have been a ton of information, just in terms of processing that and turning it around into something that's a policy deliverable.
Excellent. No, and I actually welcome the interest in participating in the regime, getting more information from the regime, and leveraging the reports that FINTRAC produces. And so I'm heartened by the engagement by my provincial colleagues in the civil asset forfeiture world. And also it reflects a growing trend internationally and new FATF standards that put a greater emphasis on asset forfeiture as a means to get the money out of the hands of criminals and redirect it to better purposes. And so I see that as a really positive thing. It was an element that we also consulted in our consultation paper, and something that we're continuing to assess in terms of what further actions we can take at the federal level, but certainly want to continue to engage with our BC and our other provincial counterparts to see what other actions or information could benefit our civil forfeiture regime in Canada, in particular in advance of our FATF mutual evaluation, which we've highlighted will come in 2025, and obviously means that 2024 will be an important year to advance those conversations. In terms of our consultation, I was pretty proud as the person who helped lead that consultation about the breadth and depth of the proposals that were put forward through our consultation process. And I have to admit that the 100 pages of proposals that were advanced were actually shortened from an even longer list of ideas that were generated both within the government, with our provincial colleagues, as well as our private sector participants and interlocutors. So we had a lot of interest in making sure that our regime kind of was fit for purpose and also was able to address the growing and emerging risks that we see in the anti-money laundering, anti-terrorist financing space. And I think we all have to recognize that the bad guys keep finding the loopholes. So we need to keep making changes. And it was a good opportunity with the parliamentary review that is to begin kind of in the very near term to look at the regime from a broad perspective and see what further amendments and changes could be brought. Yes, we received 130 submissions to the process, and all of them were substantive, which is fabulous. We got comments on almost every element in the consultation paper and feedback that really was thoughtful and provided really concrete solutions and proposals in response to the consultation document. One of the key commitments was the regime is important and participants are pleased to participate in the regime. They're continuing to add new participants into the regime is something that many supported, particularly making sure that we take a risk-based approach to targeting those areas of highest risk or emerging risk within our country. We had strong support for deepening our ability to get enforcement outcomes, and there was a complete section on the Canada Financial Crimes Agency, and there was a lot of interest in how such an agency could help improve the investigation, charges, and prosecutorial outcomes in Canada, which I think many recognized as one of the areas where we can continue to see improvements. And this obviously was reflected both in the Cullen Commission Report, but also in many other assessments of Canada's anti-money laundering, anti-terrorist financing regime. There's also a lot of interest in improving information sharing. And I think we've talked about a lot of the things that we've already done, but that more can be done in this space. There was a lot of interest in enhancing private to private information sharing. So allowing reporting entities to be able to share information to try to better piece together the web of transactions that the criminal organizations are using so that they can have a better understanding of how these actors are behaving and provide clearer, more actionable intelligence to FinTrack and then to law enforcement to be able to take faster and more coherent action in that space. And so we continue to analyze the feedback that we received, some of which informed the actions that we took in the fall economic statement. So for example, the feedback with respect to combating environmental crimes directly fed into actions that Canada took to bring ACCC, so Environment and Climate Change Canada, and the Department of Fisheries and Oceans into the regime as disclosure recipients to be able to attract those. And we will continue to use the feedback that we received and engage with partners to kind of dive into some of these trickier issues to inform our further policy work and future measures going forward.
Great. Just to unpack.
If I could just.
Sorry. Go ahead, James, please. Yes.
Thanks, Jeff. Yeah, on just this conversation of exchanging or opening up more entities for FinTrack to share information. Aaron mentioned it right at the very end there, that ACCC and Oceans and Fisheries Canada will now receive FinTrack information, which is great. It's great to hear that the government is looking at this kind of whole of government approach to who is affected by money laundering, which you could kind of encapsulate just about every sector. And as everything becomes more high profile, I think the thing after that to bear in mind, and I'm sure finance is already thinking about this, but I'm wondering if Aaron, your colleagues on the other side who are now privy to FinTrack information are ready to receive that data. So where it sounds like Phil is very ready to receive the data and very ready to comb through it, there are institutions that still need probably to be educated about how to use the information. So on top of the legislative side of access to information, I hope that the government sees the value in allocating resources to educate and give the tools to receive and analyze that information from departments who probably aren't used to it.
Yeah, good point, James. I was going to talk to another part of that, which Aaron averred to the private to private, just so folks know what that is, or part of what that is if I'm at the Bank of Montreal and I'm the chief anti-money laundering officer and I identify a rogue client, I will demarket them and I will file with FinTrack and let them know I've got a bad guy. I don't want to bank them. The problem I've got, though, is I can literally watch them walk across the street to the Royal Bank of Canada and open an account. And the only thing I can do is hope that FinTrack will call RBC and let them know. And that to me is insane because there's a ton of work that goes into a bank that makes a demarketing decision. They don't make them lightly. They lose money when they do them. And hopefully that's one of the areas of change. David, I want to turn to you. So two questions. One is there any thought in BC to having, say, credit unions talk to each other, or do they have the same kind of privacy barriers? And then the other question that is, will BCFSA coordinate with FinTrack when they issue AML guidance to credit unions in the province? So those are the two questions, David, if I could direct to you.
Yeah, a bit of speculation there, but I would, in reverse order, I would say yes, we would very much want to be part of that, and FinTrack would want us to be part of that. So yes, I think that's all going to be coordinated. We talk with FinTrack often. We have regular meetings, and then between the various segments, as well as more generally, and then ad hoc as things arise. Sorry, what was the first one? Just got so busy there on thinking about the second.
Sorry. So in the banking world, in the federal banking world, David, two financial institutions can share information between each other if there's fraud. Right. So if I'm a fraudster and I'm in BMO, then BMO's CAMLO or fraud unit can call the FIU over in the RBC and say, this guy's a fraudster. But if it's just money laundering, the bank, the BMO will demarket me because I'm a rogue client, but they can't tell the Royal Bank of Canada that I'm a rogue client. And I'm wondering whether if one credit union sees someone, they demarket them and they go across the street, can they call the credit union across the road? Or is there some thought to how they can share information with each other about typologies and bad clients and that sort of thing?
Yeah, well, we're under privacy restrictions. I know that was something that was of concern, threaded its way through the Cullen Report, and those kinds of changes, we'd have to have some legislative changes in order to do that. And people are mindful of it. I'm not aware of anything actively being done there to achieve that, but it would definitely be a valuable thing. Of course, you can share with law enforcement agencies. Those kinds of things could be shared with BCFSA as a law enforcement agency, but between credit unions, there's still that privacy block.
Thanks. James, I'm going to start with you on the next question, and then Aaron, if it's okay, turn to you. So James, the question is, what are the prospects for all provinces and territories working with the federal government launching a beneficial ownership registry? Alberta, ? I guess. And then Aaron, maybe you can unpack a little how this is going to work for a reporting agency reporting entity in terms of their KYC and due diligence when they see a discrepancy in what the UBO will be at the time when it comes to force. But James, I'll start with you.
Yeah, I think I'm hopeful that there is a really good prospect for cooperation. We already see it directly in the BC legislation that they want to cooperate with the feds, which is excellent. Quebec has beneficial ownership transparency data in their corporate registry, so it's a matter of them deciding to cooperate with the feds. And the reason we want this cooperation as well is that we want standards in data. I'm sure for any reporting entity to, if you're incorporating multiple jurisdictions, to change the data that you're uploading to the government just creates more confusion, and there's more room for people to change the data between jurisdictions and get lower the chances of being caught, and also one jurisdiction might wind up having the least amount of data be publicly accessible. So we also don't want that. So this is why it's great to have everybody harmonized. Whether the provinces and territories create beneficial ownership data within their own corporate registry and go through an API to feed that information between the feds and the provinces and territories, or if they decide that it's too much, say for a smaller resource province or territory, to house that information on their tax filings or on their corporate filing information, having a section at the bottom, amending legislation so that a section on the bottom for beneficial ownership information says that this information will go directly to the federal registry, and amend legislation so that that can happen. That might be an easier solution for some of the smaller provinces without the resources. I think those provinces probably will work this out. Again, Ontario is the biggest economy in the country. I think there's an obligation there and even a self-serving purpose for Ontario to go ahead. Does this leave Alberta as the holdout? I don't know. I would hope that Alberta does not want to be the last province to jump on board and be singled out as Canada's holdout secrecy jurisdiction, nor do I think any province would want that. I know that there was some quibbling, let's call it, whenever the report to the Minister of Finance in BC was completed about the amount of, or the quantity of money laundering that occurs in Canada happened, and Alberta got flagged as the highest. Maybe there can be disputes on the modeling that was done, but to say that Alberta is somehow immune to money laundering that the rest of Canada sees, is not a thing. Whenever one of the reports at Transparency International Canada that we did was called Snowwashing Inc., where we profiled the incorporations agents overseas who are selling Canada to their clients as a place that you'd read their websites in English or Mandarin or Russian that come right up to the line of saying, take your dirty money to Canada. One of the cases that we profiled of the shell companies that were used came from a public report in the Globe and Mail and included Alberta Limited Partnerships. So yeah, it's anecdotal, but Alberta is definitely in there. So I know we're talking Alberta, but there's other provinces I could pick on as well that have dragged their feet in recent years. New Brunswick. It was only through public pressure that they made changes. So I hope everyone wants to play ball with the feds on this.
Aaron, over to you.
No, it's an excellent question. And I think one of the things that we have to remember, unfortunately, is that shell companies are used in a majority of money laundering schemes. And FinTrack data continues to prove this, so that we recognize the importance of addressing this concern in Canada. And as James reported earlier, if we leave a gap within our coverage, it's likely that that gap will be exploited. And I think it's important for us to continue to advocate in favor of a pan-Canadian approach to beneficial ownership. You spoke, or you asked a question with respect to discrepancy reporting. So the legislation brought in a regulation making power to leverage the PCML-TFA and the reporting entities under the PCML-TFA to help address material discrepancies. This work is still ongoing. So we're in the processes of developing regulations for consultation, and then they would move to publication through the Canada Gazette to be able to see how we can improve the registry at the federal level with the leveraging the KYC processes and the knowledge that our reporting entities have. This is supposed to complement processes that Corporations Canada will have to maintain the integrity of the registry. So it's just they're complementary processes, but we recognize, and I think we've learned from our international partners, that the registry is only useful if the information is trustworthy and accurate. And so these things we think are important to be able to create and advance a Canadian registry that meets those criteria.
Thank you.
Just to jump on, sorry, Jeffrey,
yeah,
about discrepancy. I mean, this is another one thing, and I think we're waiting for the budget for Corporations Canada and for regulations and a little bit more knowledge about the inner workings of the proactivity of the registrar at Corporations Canada. how much are they going to be proactively looking at the data and doing their own analysis, and how much will FinTrack be proactively looking at the data? I think, not just putting it right back onto the reporting entities, but the government holding that liability a little bit. So it'll be interesting to see what comes in the pipeline on budgets and powers.
Yeah, and I think that the role of civil society there is just going to be massive. If you look at where they found problems in France and the UK, it's been Transparency International UK and others that have said, hey, there are 33 companies that have Joseph Stalin as a director or whatever, or Mickey Mouse or Donald Duck. So, Phil, I'm going to turn to you, and this is an AML question, but as a lawyer, I thought maybe you want to sort of think about it. The question is, AML measures have to comply with the charter to withstand scrutiny in the court. What's considered reasonable, has what is considered reasonable in terms of all of these measures we're talking about, has that evolved over time? Has it changed in terms of how the courts are looking at all this kind of, all the measures, including civil forfeiture?
Thanks, Jeff. And I'm not sure if you're saying, is the question asker a lawyer or is the receiver me, the lawyer? I can confirm me, the receiver, is not the lawyer. Tough question. Charter, I spent 25 years in the RCMP with Charter. You live the Charter life on everything you do. And certainly Charter has, we knew right from day one in civil forfeiture that, the sins of the father get delivered on the sins of the son. Out it comes. That said, the case law we continue to see in Canada is there is a reluctance to apply the same level to someone's civil liberties as $5 million of fentanyl covered cash. And the question is similar to Hell's Angels and taking that case up to the Court of Appeal and almost to the Supreme Court of Canada. Do we have to get there to the Supreme Court of Canada to get some clarity as to where the bar is for Charter as it relates to breaches with respect to search and seizure? And how does the court apply that as it relates to property? We think, at least from the preliminary cases we've seen across the country, that the court is going to apply a different threshold. It's not going to give it carte blanche, but I think they will. They see a significant difference between civil liberty, a person's liberty, and a person's property. And the other thing is, what we're seeing is we've had cases where corporations have stepped forward to claim charter breaches. And can a corporation step forward and argue a charter breach, which is, as a person, which is unique? So I think this case law is developing. The question is, can you get the right test case to go upstairs all the way and have this adjudicated? We know it will have a bearing. We just think it will have a lower bearing, but that remains for which province will find the right test case, similar to a Chatterjee or Angel Acres, to run it to the distance.
Great. Aaron, I'm going to put in the next, it's an interesting policy question here. It says, performance measures are an ongoing pain point, i.e. does the AML regime actually reduce money laundering? Do the benefits of the regime exceed costs? It'd be helpful to hear more about improving measures to show the mitigation of financial crime risk, as opposed to merely complying with requirements. I'm sort of paraphrasing, but I wonder if you want to sort of take that one on.
I think it's an excellent intellectual question, and one that I think I could equate in some ways to public health. Preventing the problem and stopping it and deterring and detecting those issues are something that's very difficult to measure, but are critical to supporting public health outcomes. And I think in this regime, that's a really important consideration. Our performance measures tend to measure concrete outcomes, number of prosecutions, number of investigations. It's things we can count. Those don't always tell the whole story, and certainly don't tell the story of an international regime with every country in the world recognizing that they need to work together to stop organized crime. And so I think that measuring our performance will always be a challenge, but I think we need to recognize that internationally, this is understood as an area that puts our economies in jeopardy, and that we need to continue to take action and continue to try to plug the gaps that criminals are able to exploit to try to protect our economies and our citizens.
That's great. So we're coming up to the end of the session. I want to start by thanking all of our panelists. This was an excellent conversation. Thank you to Mr. Justice Cullen for his remarks, and thank you to all the panelists for their remarks and their Q&A. And I'd like to remind people there's a fabulous series of webinars that are going to be every Thursday in this time slot. Some will be 60 minutes, some will be 90 minutes. And we're going to go run through a whole bunch of really interesting issues. I'm going to have one of the top crypto experts in the world come and talk to us. We'll talk about FATF. We'll talk about the role that civil lawyers can play in chasing assets on behalf of their clients in the private litigation system. We'll have talks about money laundering. Aaron and a colleague from FinTrack, Patricia, are going to talk about some of the policy issues that are out there. We'll have some police officers and crowns and civil forfeiture folks to talk about some of the disruption measures. So I welcome everyone to look at that when it comes up and participate. It's free and it's fun. And on that note, thank you everyone for your great contributions. Thank you.